Thank you for allowing me to present the key findings of the research. I must justify my perspective at the beginning of the presentation. I'm a lawyer, and in addition, I'm also a labor lawyer. So I will use a kind of similar language, although the perspective will be a purely law and economics one. Now, the goal of the paper, which I have the honor to present here at the Georgia Rota Conference, is to provide a kind of conceptualization for understanding and also unpacking the business model of some platforms. And of course, just to clarify, I'm going to discuss about the phenomenon of labor platform, that are those online platforms that allow the matching of labor demand and supply. And the two main research questions that I will try to address in this presentation are the following one. The first one is about the challenge posed by this digital transformation of intermediaries to the notion of hierarchy. So the key point that we will try to tackle is whether the notion of firm is still appropriate to face these transformational realities. And the second part of the presentation will be devoted to understanding whether the Coase theory, distinguishing between market and firm, and additionally the points and the perspective added by Powell about networks, is still relevant to depict the ongoing digital transformation. This is the structure of the presentation. I'm going to clarify and to narrow the scope of the presentation, which is about, again, online platforms matching labor demand and supply. Then I will try to recap very briefly the Orthodox taxonomies in terms of markets, hierarchies, and networks. But I will try to stress the importance and the relevance of this theory that was elaborated by Ronald Coase and then by Williamson and complemented by Powell and Malone for labor lawyers. And in particular, I will try to describe and to argue in favor of the conflation between, on the one side, the notion of firm and the employment relationship, and on the other side, the notion of markets and self-employment relationship, the role of independent contractors. And then I will try to answer to this final question. Does Uberization or platformization redefine the notion of the firm? Very briefly, we are facing in the labor market many concomitant trends that are somehow redefining the boundaries of the market itself. Some trends are long-lasting and some others have been somehow accelerated by the digital transformation. We are witnessing the collapse of the manufacturing sector, the rise of the service-based one, but also other demographic dynamics, environmental and health issues, together with the role of globalization, digitalization, and also the pervasive role of ubiquitous digital devices. What is my point of view here? As I stressed at the beginning of this presentation, I claim, and this is of course a sort of opportunistic statement, but I claim that labor law can be seen as the area in which transformational new realities are revealing their strongest impact. And of course, we need to strike a balance and to solve these tension between unleashing innovation and new disruptive business models and safeguarding workers' rights, in particular, the rights of those that are classified as providers according to the taxonomy that is used by many players in this sector. And of course, this trend, that is the digital transformation of labor market, is also serving as a test bed for assessing the suitability and also the flexibility of labor institution. So even if the theory was developed by Ronald Coase back in 1937, almost 100 years after, we are still dealing with this dilemma. And again, this new opportunity afforded by online platforms can offer another occasion to test the effectiveness of the theory. Now, when it comes to digital transformation, there are many trends and phenomena that are lumped together under this very widespread definition. Again, I will try to address the promising word of platforms such as Uber, Deliveroo, Glovo, Amazon Mechanical Turk, and so on. Those platforms that are responsible for exchanging what labor lawyers call labor energies, work, in a word. There are some important features of this infrastructure that need to be taken into account. Of course, in this sector, ICT, technology, the platform, the app on a mobile device are used to minimize transaction costs and to make the intermediation of labor more convenient and even easier to some extent. From a labor law perspective, this is somehow problematic because the source of the main competitive advantage of platform is gained thanks to a sort of regulatory arbitrage. Why so? All workers providing energies, thanks to this infrastructure, to the digital platform, are classified as self-employed workers. Therefore, they are excluded from all relevant and meaningful labor law protection, both at the individual and collective level. At the same time, they cannot be able to have a paid sick leave, a minimum wage when it is provided, or other kind of protection, including the exercise of collective rights, which is very often limited by platform and also by a narrow conceptualization of antitrust law. We are now familiar with the key elements of this new model for exchanging work. Some activities are broken into their smallest components. They are outsourced to a large pool of workers that are instantly hired on the spot to complete a discrete task. And more often than not, at least three parties are involved: the platform, which is the matching infrastructure, the client, which is the requester, and the provider, who is a worker, of course, normally. There are two main models that are crowd working, activities that can be completed remotely, potentially from all over the world, and work on demand via platform, that are activities that need to be performed at the local level, involving an interaction between the requester and the provider. Now, even if many platforms try to market this phenomenon as a totally unprecedented new world, platform work shares many dimensions with other and more traditional forms of non-standard work, including casual work, marginal part-time, temporary agency work, which is already a triangular structure when an agency is involved, but also with two other problematic forms of non-standard forms of employment that are dependent self-employment and bogus self-employment. That is a relationship that is falsely classified as autonomous. There are many risks and opportunities that, of course, can be considered. I'm going to skip this very detailed analysis because, according to the point of view, of course, this can be a wonderful opportunity in terms of activation of the labor market. On the other side, it can be seen also as a driver for precariousness. Wages are very low. The income is paid on a per drop or per delivery basis. The challenges posed are manifold because also the workers that are involved are suffering the most looming consequences of this system that we could classify as organized irresponsibility. But this is the background of the research. I did my PhD on the individual implication of platform work from a labor law perspective. But one of the most fascinating strands of the research is about the platform business model. And this can be very relevant for labor lawyers, of course, that at the moment are interested in the legal battle around the classification of workers. Are they authentically self-employed workers, or are they employees, dependent workers that are only classified as such to circumvent labor law? Now, if we base the analysis on the theory developed by Ronald Coase, we may easily understand that we're facing this kind of stark contradiction between liquid responsibilities and strong managerial prerogatives. This is not my point of view, of course. The Court of Justice of the European Union in 2017, in the Uber case that started in Spain, that was decided by the Court of Justice of the European Union, clarified that the platform is exercising a rather strong and significant managerial power. Of course, the Court of Justice avoided to solve the conundrum of the legal classification of workers, but the element of control that is distributed was taken into account by the Court of Justice. And this pervasive control was exercised over terms and conditions of the relationship, over workers, including the possibility of excluding them from the platform, which is rather relevant in terms of power relationship and concentration. Apparently, this may seem as a wonderful win-win option because platforms are exercising rather significant managerial prerogative without aiding to bear the subordination cost in terms of employment law and social security. Just to recap the fundamentals of the theory, at the moment we should discuss about the dissolution of the originally vertically integrated firm. What is the point? A part of my research has been devoted to the attempt to argue that social institutions are flexible enough to accommodate even the most innovative forms of work. And since we are facing this kind of blurred models between platforms that are classified as intermediaries, even though they to some extent exercise a rather potent form of control, I will try to use the theory to understand how platforms are behaving in the relevant markets where they are situated. The crucial element here is that, as I said in the introduction, ICT is apparently used to minimize transaction costs to the benefit of the platform and to the benefit of the final client, that instead of relying on the so famous yellow pages, can easily resort to a digital hub that is already included in the smartphone to hire a worker on the spot. According to the original theory, transaction costs are those costs that are incurred in by players when they need a specific resource. They can be divided into three different costs. The cost for resourcing, that are the costs connected to the need to obtain accountable information. The cost for transacting, that are the costs about negotiating terms and conditions of a given relationship, and then the cost for the implementation and the enforcement of the contract. According to Coase, of course, by bringing resources within the firm and by establishing a vertically integrated enterprise, it can be easier to lower transaction costs, and it could be easier to grow for a company. Why so? Because the coordinator, the entrepreneur, can exercise managerial prerogative. And this is crucial. This is where the theory developed by Ronald Coase meets labor law. Of course, this kind of binary divide between markets and hierarchies has been already complemented by other scholars who have tried to explain how these models should not be seen as a on-off toggle, but rather as a continuum, as a spectrum. And in particular, when it comes to understanding the alternative models, we need to take into account, of course, the fact that activities can be completed internally, thanks to the vertically integrated firm. They can be completed externally, thanks to commercial contracts, namely contracts that are outside the protective scope of labor law, or there can be a different arrangement that is based on networks. That is a system where there is a sort of interdependence among players that are involved in the transaction. Now, this theory has been crucial for understanding the institution and the foundational role of labor law. For one important reason. Again, the vertically integrated firm is a system where, thanks to the legal framework developed in the last century, the employer and also managers, of course, are allowed to exercise strong managerial prerogatives without the need of obtaining the consent of the debtor, that in the employment relationship is, of course, the worker. Now, of course, this theory is very raw, and it has been somehow expanded by other scholars by bringing within the picture the role of networks. There are these models where there is a sort of interdependency, even if very often networks do imitate a vertically integrated firm, also because of some specific investments that are made by some players, and in a way they are also responsible for developing a certain ties that can be overcome. And then, of course, the other crucial element that we need to understand is the conflation between the vertically integrated firm and the possibility of exercising the fully fledged managerial authority. According to Coase, the firm is a sort of authority system where one private party is entitled to exercise a very significant and strong power over the other. This is rather important, and even if at the moment we can find some degree of authority also in different relationships, including in non-employment relationship, the basic understanding of the theory is that in the vertically integrated firm, the employer, who is the coordinator, is entitled to do basically three important things: that is, organizing the workforce, surveilling and monitoring the execution of the contract, and sanctioning the non-compliant behavior of those workers who may be caught in breach of the contract. So there is a perfect overlapping, I would say, between the employment relationship or the contract of employment and the hierarchy, which is the vertically integrated firm, and on the other side, the self-employment relationship and the market. But again, just to clarify, labor law has developed by limiting the latitude of this managerial power exercised by the employer. At the same time, the legal institution in the field of labor law allow the exercise of the organizational, monitoring, and discipline power while constitutionalizing them, while making them compliant with our principles and values. Now, this is the theory, of course, and we may try to understand whether it is still relevant in the second machine age, in the digital age, whatever you want to call it. So, as I said before, we have alternative ways to lower transaction costs, in particular digital infrastructure, including some new HR practices such as people analytics and management by algorithms, can easily replicate the model by leveraging the customers' reviews, for instance, or the evaluation that are left after the execution of a contract by the final clients. Or terms and conditions can be stipulated algorithmically thanks to some standardized formats that can be only accepted by those that are involved in the relationship. And then there can be a system based on some specific elements that need to be assessed in order to lead to a potential exclusion from the platform on the basis of some digital devices. This is my final contribution. If we need to classify the platform according to the scheme that was developed by Ronald Coase, this can be somehow problematic because platforms, and in particular labor platforms, are behaving as firms when it comes to exercising this command and control position of the workforce, but they are using commercial contracts in order to avoid the obligation that are afforded by labor law. At the same time, as was clearly explained in the previous presentation, they represent also a system that is based on network effect. The higher the number on the one side of the market, the higher the interactions on the other side of the market. And if we consider this very broad brush representation, of course, in picture number one, we can find the perfect example of a vertically integrated firm where resources are brought within the boundaries of the firm. The second example is the market. Try to call a plumber late at night on a Saturday evening. The plumber is able to make the price in a very autonomous way. the fair picture depicts a network like BlaBlaCar when underutilized resources are shared. When it comes to labor platform, I argue that we are facing a new model that is encapsulating all the previous model. This is why I use the expression of the Cerberus sphere, that is a three-headed monster behaving as firm when it comes to exercising control power as a market, because the providers are classified as independent actors, but also as networks, because there is a system of interdependence tying the players to the platform. This is somehow astonishing because outsourcing, flexibility, authority, and control that are, at least in theory, antithetical, are combined together. And this model of firm, that is a perfect combination of the plural models that I described before, can be also classified according to this wonderful model that was developed by Powell. I added a final column to describe the operation of a labor platform according to the already existing alternatives. So what is the final answer to the research question that I made at the beginning of the presentation? Does platformization redefine the notion of the firm? My answer is no. Uberization does not reboot the notion of the firm. On the contrary, it perfectly clarifies the meaning and also the relevance of the theory developed by Ronald Coase, the alternative between make or buy. What is the current problem? The current problem is that many platforms basically want to have it both ways. So they enjoy the possibility afforded by a scheme based on employment while avoiding all the labor-related responsibilities in terms of labor law and social security. They use tech to connect the players. They avoid the classification of providers as employees, and this is the key source of the competitive advantage. And finally, this is the crucial point. Even if the original theory is somehow under pressure because of these new players that tend to present themselves as totally novel operators, I would argue that the original and traditional demarcation is still relevant, is still important, and we should avoid the sophistication of language by refusing all these intermediate definitions such as intermediary, matchmaker, and whatever, because at the moment we need to solve this tension and we are dealing with controversial results in terms of balancing between the powers exercised and the responsibilities accepted by platforms. Thank you very much.